All rise. The Court of Appeals Division 1 is now in session.
Thank you all. Please be seated. This is the time set for oral argument in Security Pest and Termite Systems of Southern Arizona versus Matthew Curtis Revelts et al. Our case number CV140237. Each side is allocated 20 minutes for oral argument. If the appellant wishes to reserve a portion of your time, ma'am, you may do so, but you'll need to keep track of your own time at the podium clock. Out of respect for counsel, I would ask that those in attendance make sure their phones are disabled so counsel's presentation is not interrupted. We've read the briefs. We've conferenced the case this morning. We'd encourage you, we're familiar with the record, we'd encourage you to keep that in mind as you present oral argument. Our proceedings are being recorded and will be posted on YouTube and the court's website in due course. As you begin your argument, please state your name and the party that you represent. With that, Ms. Freeman, you may begin.
Thank you. May it please the Court, Susan Freeman on behalf of Security Pest and Termite Systems of Southern Arizona, DBA Yuma Pest. The Court's grounds for denial of preliminary injunctive relief were wrong as a matter of fact and law, and this matters not just because preliminary relief should have been granted, but also because the Court's determinations will have an effect upon the request for permanent injunctive relief as well as damages as the case proceeds below and there's ongoing discovery evidence about use of confidential customer information. I would like to save 5 minutes of my time for rebuttal, and if I may, let me just start with 5 quick places in the record where the Court's findings were wrong before we get to a discussion of the law. First, the Court found no evidence that Mr. Revelts is or was an employee of Ram Pest. I would ask the Court to look at Exhibit 23 and I-125 at 49 to 52, which are state reports of Mr. Revelts working as a licensee for Ram Pest as licensor, or for Ram Pest as licensee as well, the employer, in providing termite services.
What was
and
the
also,
second site? IR.
I-125, the index 125 at 49 to 52, and Exhibit 23. And then Exhibit I-4, the order to show cause, covers a contractual interest, and Court of Appeals 14 at 12 to 13, 24, and 40 explain that contract. Second, the Court found no evidence of Revelts' direct solicitation of Yuma Pest customers to change to RAM. I would ask the Court to look at Court of Appeals 48, Garner 8 to 14, and ACOC 33 to 36, which are use of the company laptop and company phone, and Court of Appeals 49, Coleman at 8 to 10, which are 300 telephone calls that were made with that company phone and with information from the database that was printed out. The third is no evidence of any potential claim that Yuma Pest had against Audra Tillman that would have been releasing in the settlement agreement, and hence no consideration. Garner, again, CA 48 at pages 82 to 84, she was involved in funds that were not deposited. I-101 at 32 to 33, there were company claims for her use of a car, and there are, of course, community liability claims for herself as Revelts' spouse. And I would note that her attorney was the one who sought the release and who was offering the non-competes in exchange. That's Exhibits 1 through 7, and Garner at 42, 43. And, of course, Mustang says that a release is valid evidence, and I would also note consideration wasn't argued below. And then finally, number 5, that there was, number 4, giving effect to tolling agreements means an indefinite extension of the non-competition period. Garner at 48 to 49, they were just seeking the balance of the 2-year period after the breach ends, and that issue is obviously a legal issue too that we need to discuss. And then finally 5, there was a finding of no legitimate interest in preventing Mindy Santos from working at Ram Pest. I would ask the Court to look at CA 48 ACOC at 13 to 33. That discusses her role in putting data on the Yuma Pest customer transactions into its unique format, its unique user codes, and her ability stepping into the same position at Ram Pest to do the same thing and to use that to give Ram Pest, the startup, a real start up in a way that it could not get otherwise, a competitive edge. So the legal issues, as I see them, they're really twofold. One is what showing of irreparable harm and an adequacy of remedies at law is needed in a non-solicitation customer use of trade secrets context. The trial court said that the plaintiff must be in danger of going out of business, and that evidence that the solicitation was now years ago shows that there was no irreparable injury, that there's adequacy of remedies at law in terms of whatever monetary damages can be awarded. I would ask the court, and then the second one is whether these tolling provision agreements are enforceable in Arizona, and that's an issue of first impression in the state. So with respect to the first, what are the standards? I would ask the court to note that we have Smith v. Clean Elections, that's from the Supreme Court, that's upholding the Schoen case, which says the possibility of irreparable injury is enough. And I would say that is not the same as evidence that you are going out of business. And it does not mean that, the fact that they are now 3 years later effectively up to square one financially doesn't mean there can be no future harm. And
it also doesn't mean that even if they're up to square one, up to where they were a little bit better, it doesn't mean that they lost other business. In other words,
absolutely,
they could have gone up 10% in their business, but if without the alleged violations, it could have gone up 50%.
Absolutely.
So, but what do you do with this, as I understand it, this testimony that says, I can calculate my damages?
Well, there are a couple of points that I would make with respect to that. Number one is that the fact that he says he can calculate damages doesn't mean that they are necessarily going to be proved at trial to the satisfaction of the trial court. Although the appellees are saying, oh, he testified that he can calculate damages, they are also saying they can't prove damages. They can't prove causation. They can't prove the amount of damages. And there's a motion for summary judgment pending at the trial court on exactly that. And there are 2 points, Your Honor, that I would ask you to particularly look at here. One is the Phoenix Orthopedic v. Pierce case, which says once a protectable interest is established in a restrictive covenant kind of a case, irreparable injury is presumed if the interest is not protected. So we have a presumption as a matter of Arizona law. The second is to look at the IB Property Holdings case, where the court cited the restatement second of contracts and the restatement second of torts, finding that the difficulty of proving damages with reasonable certainty certainly has a big bearing on whether you can prove irreparable injury. And it quotes 360 Comment B of Restatement Second of Contracts, breach of a covenant not to compete causes the loss of customers of an unascertainable amount. And Restatement Second of Torts, 944 Comment D, estimates of business diverted via unfair competition necessarily contains a high degree of conjecture. I mean, this is not like a back pay case where you know the date that the person was terminated and you know how much the pay was.
But it still seems to me that where a client comes in and says, look at it from the trial court's perspective. Mm-hmm. Trial court's hearing the witness say, I can calculate my damages.
Right. Now,
no one knows what's going to happen at trial when he tries to do that. Maybe it won't be sufficient. Maybe it will be sufficient. But trial court is faced with this fairly important statement that says, I can get damages out of this, and I can prove my damages.
But he did not say that there was no future ongoing damage. What he said was he thought he could prove damages for the period of time that he had calculated, but he didn't say that there was no ongoing use, and rather the testimony was to the contrary, that there was ongoing use of these trade secrets, this customer database.
Right, but if there was, could he prove the damage? Did he say, and I can't prove the damages for this ongoing?
He was not asked that question. And the issue is the company does have ongoing damages because you do have this database of information, these unique customer codes, this unique information detail about the customers that was in fact taken and was used for at least the initial customer calls.
But if in fact the witness testified that he could calculate damages up to a date certain, is it unreasonable for the trial court to understand that he could do that using sort of the same formula going forward? I mean, I understand your argument, and there is an answer that you've, actually two answers that you've provided to that testimony, but that testimony doesn't appear very often in preliminary injunction hearings. And to me, the question is not whether the trial court could have discredited that testimony, but whether the trial court abused its discretion in accepting that testimony effectively whole cloth.
Your Honor, I appreciate the point that you're making. I would ask the court to look to the Overholt case, which is from the Eighth Circuit, but it was one of the cases that was cited and argued to the trial court below, and it's one that says in particular that you may get damages for losses so far, but you need the permanent injunction to protect against additional loss of customers. And if the court is not persuaded that the preliminary injunction should have been granted, I would urge the court to at the very least rule with respect to the preliminary findings and with respect to the ability to get injunctive relief as well as damages for the permanent injunction that we'll be seeking at the trial court on an ongoing basis.
But the
because the
preliminary
court's
injunction
reasoning would preclude that, and that's a problem.
But that issue would be resolved, and I appreciate what you're saying, but on a different factual body of evidence. I mean, there is no preclusive effect from the preliminary. The legal issues would apparently be law of the case, but there's no preclusive effect when you get to the final or permanent injunction phase.
That's true. There would be additional evidence at that point in time. The concern here is with respect to the court's findings with respect to things like you have to prove that you're about to go out of business, and that the fact that the actual solicitation happened a few years ago at this point in time means that you're not entitled to injunctive relief. Those are the real problems that we're concerned about going back. Now, just as an aside, I absolutely agree with you with respect to this not being binding on the factual findings about, preliminarily, I think you're most likely to prevail and so forth. And the legal rulings being law of the case that are subject to, of course, modification as the case goes forward. And I would note that that is a reason why the cross appeal is not well taken, because it was never an issue in the first place. It certainly should not warrant attorney's fees award because you bring up an issue that is not really in dispute.
So if you're asking that the decision address the finding, at least the findings about, to the extent the court said, or it could be read as saying that, gee, these things occurred 3 years ago, so why are we here on a preliminary injunction, and that you have to go out of business or be on the verge of going out of business to show irreparable harm, that if the decision said something about either that the court didn't, that shouldn't be interpreted as binding at the permanent injunction and it's not the standard.
Absolutely.
That would be enough.
Those are really important, and that you're not entitled to, that there is no irreparable harm because you might be able to get damages. With respect to the timing, I would ask the court to look at the Emke case, Enterprise Leasing v. Emke, where it's very similar in terms of the underlying factual context with respect to taking a customer list that had more detailed information about the customers and taking information about how the overall business is run and using that for a competitor. The court did not hear the preliminary injunctive, did not hear the evidence on the preliminary injunction for a year after that solicitation and granted a preliminary injunction. The employee then moved to a new company, again misused the trade secret information, and this court said, oh, well, it's not trade secrets at this point. This court said on appeal that it was trade secrets and reversed for the trial court to consider permanent injunctive relief. So that is a year later. Then in the Prudential v. Porchero case, the actual solicitation was in 1982. The injunction was issued in 1985. And it was again upheld by this court, saying that they still had the information, the trade secret information, and could still use it, now 3 years later. So, this is a situation in which there is not unreasonable delay. They find out about the solicitation. They find out about the misuse of trade secrets. They act immediately. They get a settlement. They negotiate something. And then once the settlement is breached, they do take some additional time to confirm that that's happening and to determine whether there are damages. And once they know that, they act in court or proceed to court, and then the court, you just have ordinary trial delays where you ask for an order to show cause, then there's a motion to dismiss, so you hear the motion to dismiss first, and that kind of thing. Yes?
On the last 2 pages of I think it's the reply brief, the appellant talks about, in pretty vague terms, about we've also been damaged by use of trade secrets about our processes.
Right. And that is similar to the enterprise leasing, the EMKI.
But I couldn't find it anywhere else. And what I understand the argument to be more generally is we have detailed information about particular clients, and when you take that information and that makes it easier for you to approach our client and steal that client, that's one thing. But I didn't see any evidence about how we manage our business is really a trade secret.
There was, and that's the information, or those are the citations that I was giving you with respect to Mindy Santos, for her being able to input this information into the customer database to set up the company in the same way. They had some unique user codes that helped them in the way that they were able to manage and process their business, and that was part of the way that they structured their PestPack database, and it's the use of that database and software and the way that they had set it up that can be, and we think the evidence going forward will show, is in fact being used by Rampest, and that is the same kind of misuse of customer information. And as I said, EMKI is finding both that and the detailed information with respect to customers to be a trade secret. Finally, with respect to the enforceability of tolling agreements, there is a split in authority on that. We think the majority of the courts are upholding the tolling of a non-compete period, both as a matter of just equitable determination by the court. And those are the Capilouto and Presto X cases in particular from the Supreme Courts of Florida and Iowa that are saying just as an equitable matter, even without having a tolling agreement. And then you have cases like EMC, Justice Souter, sitting for the First Circuit, who said, well, in Massachusetts it's not allowed, but says, but you could have had a tolling agreement.
But this tolling agreement, does it extend until, as long as there is one breach? Does it extend as to all customers if one customer is stolen? Or does it extend only as to that customer?
Well, I think to the extent that any breaching is occurring, that the court is finding a breach, once the court determines that there has been a breach and is entering relief, then that's the point under this case law that the court would say the 2-year period starts running, because at that point.
But if I steal one customer, does that extend the non-compete forever for all other customers, as long as I have stolen and kept that one customer?
I don't think that that's the case, Your Honor, but I think that that's, I don't think that's what the court was ruling, or that that's been the case in any of these decisions. Instead, they are giving an injunction against ongoing use of the database, ongoing solicitation, and saying this solicitation, this misuse and abuse of trade secrets has occurred. Stop it going forward, and as of right now, as of the date of the entry of the order, I'm going to have your 2-year period run. And that's what those cases are saying.
As to everything. So, in other words,
not as to the trade secrets, as to the non-solicitation, there are 2 time periods. There's a 2-year period with respect to the non-solicitation and the covenant not to compete, but then you have a don't use my trade secrets that is open-ended. And those, there is a distinction, and our courts and ones like Gann recognize that and allow that to go forward. And so I guess one other point, that there's a recognition of a difference between abuse of a trade secret and a non-compete.
If there's a non-compete violation,
yes.
As to one, I know you're running out of time, and we can deal with that. But Well, that's all right. That's all right. Go ahead.
So just one last point. I would note Delta Entertainment is a case that points out that these tolling agreements are especially effective when it is negotiated by counsel and in exchange for consideration. And that's what you have here. And if I may, I would like to have my last time for rebuttal.
Very well. Thank you. Ms. Rosen.
Good morning, Your Honors. My name is Luann Rosen. I'm representing the appellees in this matter. The first point with regard to irreparable harm, the witness Acock was asked specifically that question. When we get to trial, are you going to be able to calculate your damages with reasonable certainty? His cross-examination talked about, he said, all right, you came up with an actual dollar figure loss to Ram Pest between the April and the July, April 2011 when Ram Pest started operating, and July 11th, 2011. He said, yes, I came up with revenue, and the counsel said, are you reasonably certain it's an accurate number? I feel it's very accurate. If we get to trial, I assume you'll say the same thing, something to the effect that that's what the loss is. Yes, sir. And I assume you're going to continue to track what you perceive to be the business loss to Ram Pest. Yes, sir. All right, and you'll do it the same way that you did this. Is that right? Yes, sir. And based on information that you think is reasonably accurate, you'll come up with whatever additional numbers there are. Yes, sir. At trial. Okay, that's because you keep track of who left and what competitor they went to and the value of the account, right? Yes, sir. So you'll be able to figure out your damages at the time of trial. Yes, sir. So this is a case where there. Go ahead.
I think I remember reading that in the briefs, but could you give me the record reference on that?
Yes, it's from Acock's trial testimony at pages 54 to 55, and that's it was a record reference in the Superior Court Record 131, and this is the order to show cause September 12th, the morning session, is where that transcript, that testimony came from.
Isn't the most certain way, though, if there has been infringement in the past, to account for that going forward, to enjoin that infringement?
Well, the Schoen case says you have to have irreparable injury that is not, what is the exact, not remediable by damages to get an injunction. So if you have, even if you claim you have an irreparable injury, but you can calculate the damages, then you don't qualify for injunctive relief.
Well, is it that you don't qualify, or is it that a trial court could consider that in denying or granting a request?
Yes, the trial court could, and here the trial court considered it and determined that they could prove that what their damages were, so that he denied the preliminary injunction. Now, granted, you might have a similar situation, which is what Phoenix Orthopedic case is, where the trial court granted the injunction, and the court said, well, you know, this court said the trial court was looking at the testimony and determined that just because there was a liquidated damages clause, that didn't mean that they still weren't going to suffer irreparable harm. And some of the cases cited in the supplemental authority on this issue, for example, the IB Property Holdings case, that's a very different case than this case. In that case, there was it was an easement case. The easement to an apartment complex was, the access was limited by a fence that was built. The witness that was on the stand said, well, when he was asked, you know, could you calculate what the damage is, he said, well, it would be speculative. It's some kind of impact on the value of the property complex and what it could be sold for, but it's certainly speculative. And the court ruled that the access needed to be provided to, on an injunctive matter, the access needed to be provided to that apartment complex. That's a very different set of circumstances than we have in this case. The McGran case that they cited is a very different kind of business. In that case, it was a business where basically you had a company that had 5 main clients. Those clients took about 1 to 3 years to develop that business relationship. They said that they invested about $200,000 per client to get those clients before they even got a booking on what they did, and that maybe they could get 1 client a year. That's a completely different circumstance that what you have in the pest control business, where there are many pest control companies. Every company has a significant loss of customers every year. That's just part of the doing business in that area. They also cited to the HTS Boley case, which was a default judgment. So there was nobody there on the other side to say, and we're not saying that there aren't cases where there could be injunctive relief and damages. But this is not a case that qualifies under the Schoen test. Here there is evidence that they have damages that could be calculated at the time of damage or the time of trial, and their own witness is the one who says he can come in and do that.
What about the argument that beyond specific information about identities of clients and those clients' particular preferences, that there were some trade secrets that were used just in terms of how to set up my business and how to run my business, what duties I give to certain employees, what I record in my database and what I don't? Were those, what about that contention?
I think one of the important things to look at here is exactly what is the preliminary injunctive relief under the order to show cause that Yuma Pest sought. And that's in record R4, that is the order to show cause. These are the things that they asked. They asked that the court divest Matt Routes and Ron Martin. Ron Martin is the owner of RAM, from any interest in Bug Warrior, which is, and there's testimony that's educational services where Matt Routes dresses up as Sergeant SWAT and goes and does some things with kids. So that was the first thing that they asked for, was divest both of those people from the interest in Bug Warrior. There's no testimony at all that Ron Martin has any interest in Bug Warrior, and the testimony with regards to Matt Routes is exactly what I just said. He performs educational services. There isn't anything in the record that shows that he goes out and applies chemicals to get rid of pests. They asked then to prevent Matt Routes, Audra Tillman, and Mindy Santos from being employed within the pest control services business for the 2-year time period and within a 50-mile radius of Yuma. So they didn't ask there. The only place that they asked that anybody not disclose confidential information, which they have really yet not specified what that supposedly is with Larry Routes and Bobby Esperanza, and those were two applicators. There's no evidence that they signed any non-compete clause. It certainly is not part of the settlement agreement. Those are only Mindy and Matt and Audra who signed as part of the settlement agreement. Larry Routes says he never signed any non-compete or non-confidentiality clause ever, and there isn't any in the record for Bobby Esperanza. So those are the only two people that they asked for an injunction against this confidential information. And it's very clear in R4, and in fact, in the answering brief, they reference it in 2 different locations that those were what they asked for in their injunctive relief, yet they're trying to broaden it with regards to saying, well, we should have gotten an injunction against those, against the other defendants also, when they never asked for that relief. With regard to the tolling provision, I don't think that the judge was incorrect in ruling that it does apply indefinitely. The tolling provision applies to all 3 areas, the non-compete, the non-solicitation, and the confidentiality clause. It's open-ended. There is no time limit there. They cited to a couple cases in their supplemental briefing, saying that the Delta Enterprise case shows that they received consideration of $50,000 for that open-ended tolling provision. We don't know what happened here with regards to the tolling provision. It was part of the agreement. We don't know if their lawyer said don't worry about it because it's not going to be unenforceable or not going to be enforceable. We don't even know what business. That case is, I think, 2 pages long, and we don't know what kind of business they were in. We don't know what all was involved there. They said that there was multiple indications of the defendant's bad faith in that case. So it really doesn't apply to you can't stretch it, in my opinion, to the facts of this case because there just isn't enough information in that case. The EMC case simply recognizes that a party can contract for a tolling provision. I don't disagree with that, but it needs to still be reasonable in terms of its scope, and it just can't go on indefinitely. With regard to the cross appeal, it sounds like everybody's sort of on the same page, where these rulings are limited to the injunctive relief sought, the preliminary injunctive relief sought, and we had asked the court to clarify that, which had not been done and still has not been done. But it sounds like everybody is in agreement that the findings relate to the preliminary injunction, that there has been no waiver of a jury trial on behalf of our clients with regards to the defenses in the case, and also the cross appeal. Also, you could take judicial notice, the case that we cited, Routes versus Stover, has since been consolidated into this case, so everything is being tried in one case. And we do ask for attorney's fees also on appeal. If there's any questions?
Thank you, counsel. Ms. Freeman, rebuttal.
We would ask the court, with respect to the preliminary injunctive relief back at the trial court, to direct the trial court to consider it again as a matter of discretion with correct interpretations of the law and the facts. And the court may well then issue preliminary injunctive relief at that point in time when it's basing it on the correct rulings. Likewise, to apply the correct law and the facts with respect to the availability of permanent injunctive relief going forward. Even if there is a damages award, and they're certainly not conceding that, in fact, we are going to be entitled to all damages, I would point the court again to the IB Holdings case, where the court said that even if some damages may be proved and recovered, that injunctive relief is appropriate if those damages are inadequate to address the full amount of damage and problems, full amount of harm that is suffered, which is often the case and is when you have a non-compete and continued use of trade secrets. With respect to the use of the database and the software, I would point the court in particular to the ACOP testimony at I-132, where he testifies at length about the database and the software and how that is protected customer information. And I would point the court to the Emke case and also the Bedmark case, where the court said your product's Bible is in fact trade secret information. And I would note that that's one of the cases that illustrates that it's not that the employee has to have special kinds of a special kind of role at the company, as they have argued, in order to be entitled to injunctive relief. It's the nature of the trade secret information that's at issue. You know, there you had just a salesperson, but he had the product Bible, and as opposed to something like the pest control company, where he was just had what he learned in the course of being a pest control person. With respect to the order to show cause scope.
And Ms. Freeman, I'll need you to begin to wrap up. But
okay. With respect to the order to show cause scope, it included not engaging in any business activity, which would include not soliciting customers, as in addition to divesting himself of an interest in Bug Warrior. With respect to the cross appeal, and they're asking the trial court to clarify, that was something on which they asked the court to do that after it had already gone up to this court, and the trial court had no jurisdiction to deal with it. Thank you.
Thank you, counsel. We appreciate your briefs. We appreciate your argument today. We will take the matter under advisement. We'll issue a ruling in due course. We're now going to take a short recess while we set up for our next oral argument. Thank you.